to the Montana Human Rights Bureau's presentation on harassment in employment, also known as hostile work environment. The Montana Human Rights Bureau is the state agency charged with investigating complaints of unlawful discrimination. Unlawful discrimination is an adverse action taken against someone in a protected area because they are a member of a protected class. The protected areas prohibiting unlawful discrimination are employment, public accommodations, governmental services, housing, education, insurance, and financial transactions. For the purposes of this presentation, we will be focusing on the area of employment. Here you see all the protected classes under federal and state laws. Montana's protected classes are the same and overlap with the federal protected classes. But note that Montana law recognizes the additional protected classes of creed, marital and familial status, and political belief, whereas federal law does not. Also note that the protected class of political belief is only applicable in the areas of governmental services and government employment, and familial status only applies to housing discrimination. Based on the definition of unlawful discrimination, you may be asking, where does harassment fit in? To explain that, let's first define harassment. Harassment can be any behavior that slanders or shows hostility toward another person because of their differences. Harassment creates an offensive, intimidating work environment and/or negatively affects a person's work performance or employment opportunities. However, it is important to note that not all harassment is unlawful harassment. Unlawful harassment is a subset within harassment. Unlawful harassment is unwelcome conduct that targets someone based on protected class status that is sufficiently severe and/or pervasive that it alters the work environment. When the Bureau investigates a complaint of harassment in the area of employment or hostile work environment, which is where the acronym HWE comes from, there are a number of laws that apply. Under all circumstances, the Bureau relies on the Montana Human Rights Act, which prohibits harassment based on any protected class regardless of the number of individuals employed by an employer. If the employer is a governmental entity, the Governmental Code of Fair Practices also applies. If the charging party asserts he or she was harassed in the workplace based on being a person with a disability, the ADA applies so long as the employer has at least 15 employees. If the charging party asserts he or she was harassed in the workplace based on being age 40 years old or older, the ADEA applies so long as the employer has at least 20 employees. If the charging party asserts he or she was harassed in the workplace based on being a member of any other protected class, Title VII of the Civil Rights Act of 1964 applies, so long as the employer has at least 15 employees. Who can harass an employee? What type of actors can be involved in a complaint of harassment in the workplace that may subject an employer to liability? The most common harassment complaints filed at the Bureau allege a coworker or a supervisor harassed a charging party based on his or her protected class. However, it's also important for employers to understand that they are responsible for controlling their employees' work environment, which means that they can be held liable for harassment perpetrated by non-employees as well, such as contractors, agents, customers, and even delivery truck drivers. There can also be employees who are not directly targeted for harassment by anyone, but are collateral targets. If an employer has 2 employees who willingly engage in inappropriate behavior and a coworker is present and subjected to the offensive banter, that person could be a collateral target. The Bureau recently had a case filed by an employee in a healthcare office. Although conduct was not directed towards the employee, she was subjected to what she called a frat house environment where coworkers and supervisors made sexual comments and noises, played sexually explicit videos in the workplace, and discussed genitalia and orgies, this employee was a collateral target of sex-based harassment. These 5 elements constitute the analysis of a harassment complaint. 1. Charging party is a member of a protected class. 2. Charging party was subjected to offensive conduct based on his or her membership in a protected class. 3. The offensive conduct was unwelcome. 4. The offensive conduct was so severe or pervasive that it altered the conditions of employment and created an abusive working environment. And lastly, 5. A basis for holding the respondent liable. The first 4 elements establish that harassment occurred in the workplace, while the 5th element looks into whether or not the employer can be held responsible for the harassment. After a charging party shows that he or she belongs to a protected class, they then must prove that they were subjected to offensive conduct based on that protected class. Offensive conduct can be verbal or physical in nature and include slurs or name-calling, jokes, innuendo, or comments, pictures, lyrics and music, blocking another's movement, pushing, and intimate touching. Whether or not the conduct would be considered offensive is judged by whether or not a reasonable person would objectively find the conduct offensive. The third element requires that the offensive conduct be unwelcome by the charging party. While the review of whether the conduct is offensive is more of an objective standard, unwelcomeness is reviewed as a more subjective standard. The question of whether the conduct was unwelcome revolves around whether the employee regarded the conduct as undesirable or offensive and did not solicit or incite it. Some examples that indicate an employee found offensive conduct unwelcome include telling the person engaged in the conduct to stop or that they do not like the conduct, making a complaint to their employer, or filing a complaint with the Bureau. An employee's nonverbal cues can also express unwelcomeness, such as leaving the room where the conduct is taking place, turning away from the conduct, or even shaking of the head in disapproval of the conduct. On the other hand, if the charging party participates and engages in the conduct, that tends to show that the conduct was not unwelcome. In order to prove a harassment claim, the charging party must also show that the offensive conduct was sufficiently severe or pervasive as to create a hostile or abusive work environment. While the charging party's perspective is taken into account, making a determination on this element is based on a reasonable person standard. It is important to note that the conduct must be either severe or pervasive, but not both. Severity relates to quality, while pervasiveness relates to quantity. Who the bad actor is impacts severity as well. Offensive conduct from a supervisor can be more impactful on an employee than just a coworker or peer. Physical touching or an unambiguous racial slur are common examples of severe offensive conduct. For example, a coworker who flicks his female coworker's breast would be severe, as would a supervisor calling his subordinate the N-word. Conduct that is not severe can still create a hostile or abusive environment if it occurs often enough to demonstrate a pervasiveness in the workplace. Minor isolated incidents, unfair treatment, offhanded comments, and disagreements are not unlawful harassment in the workplace. Federal and state anti-harassment laws are not meant to be a civility code. In order for a charging party to prevail on a complaint of harassment against his or her employer, there must be a basis for holding the employer liable for the harassment. If the harasser or actor perpetrating the offensive conduct is a coworker or a non-employee, then there are 2 steps or questions to determining whether or not the employer is liable for the coworker or non-employee's harassment toward the charging party. The first step is determining whether or not the employer either knew or should have known about the harassment. For example, the Bureau had a case where a coworker yelled out a sexually derogatory name in the workplace whenever the charging party entered the room. The coworker did so at least once, if not more, in front of their supervisor. Because the supervisor knew this sex-based harassment was occurring and was obviously part of management, the employer knew or should have known that the harassment was taking place, even prior to the charging party coming forward with a complaint once that coworker physically touched her. If it is determined that the employer knew or should have known about the harassment, then the next question is whether or not the employer took immediate and appropriate corrective action to put a stop to the harassment. In the example just given, the supervisor did nothing to stop the coworker from calling the charging party inappropriate sex-based names, nor did the supervisor report the conduct to his superiors. His position as supervisor imputed that knowledge about the harassment to the employer. His inaction also meant that the employer took no steps to stop the harassing behavior against the charging party. Therefore, employer was held liable for the coworker's harassment towards charging party. The immediate and appropriate corrective action an employer takes must be calculated to stop the harassing behavior. If the harassing conduct continues, the employer must take progressive steps against the actor that are again calculated to stop the harassment. Many times, an employee being harassed wants the harasser immediately fired. However, whether or not an employer took immediate and appropriate corrective action against a harasser is evaluated on a case-by-case basis. For non-employees, an employer with knowledge of harassment is required to take immediate and appropriate corrective action within its control. For example, if a waitress reports to her manager that a customer patted her on the behind, or the manager saw it happen, and the manager does nothing, the employer could be liable for the customer's behavior. The corrective action could be as simple as telling the customer the behavior is not tolerated in the restaurant, or if it is a more serious situation, the customer could be asked to leave. There are a couple different considerations for determining an employer's liability if the harasser is a supervisor of the person he or she is harassing. But first, we must discuss what makes someone a supervisor. Title alone is not sufficient to determine if someone is a supervisor, and determining status should be done on a case-by-case basis. An individual qualifies as an employee supervisor if A, the individual has authority to undertake or recommend tangible employment decisions affecting the employee, or B, the individual has authority to direct the employee's daily work activities. Tangible employment decisions are decisions that significantly change an employee's employment status, such as hiring, firing, promoting, demoting, and reassigning the employee. An individual with the authority to make these types of employment changes is a supervisor, even if that individual does not have the final say on whether to enact the changes, so long as the individual's recommendation is given substantial weight by the final decision maker. However, even if an individual does not have authority to undertake or recommend tangible employment decisions, he or she may still be a supervisor if they make decisions regarding daily work assignments, even on a temporary basis. A supervisor harassing an employee outside his or her chain of command may subject the employer to liability if the employee reasonably believed that the harasser has authority over them based on the harasser's influence or an unclear chain of command. However, if that is not the case, a supervisor harassing an employee outside the chain of command is analyzed like a coworker harassment case. When someone in a supervisory capacity subjects an employee to a hostile work environment, the employer may have an affirmative defense. If an employer can prove that it discharged its duty of reasonable care and that the employee could have avoided all of the harm but unreasonably failed to do so, the employer will avoid all liability for unlawful harassment. This standard lays out that both the employer and employee have duties to take reasonable care. The employer has a duty to exercise reasonable care to prevent and respond appropriately to harassment, while the employee has a duty to exercise reasonable care to use the employer's preventive measures or complaint procedures to put a stop to the harassment and avoid harm. To successfully raise an affirmative defense, an employer must prove it took reasonable steps to prevent harassment, such as implementing appropriate policies and educating its workforce, that it took prompt steps to correct any harassment that occurred, that the harassed employee unreasonably failed to take advantage of the employer's preventative measures, and that all harm could have been prevented had the employee complained in a timely manner. If both parties exercise reasonable care, the defense will fail. While this may seem like a high hurdle to jump for a law-abiding employer to avoid liability, this standard is consistent with liability standards under anti-discrimination statutes, making employers liable for its supervisor's discriminatory acts. For example, if a supervisor fails to hire a candidate based on race, that employer is liable for the supervisor's failure to hire based on a protected class, regardless of whether or not the candidate complains to higher management or whether or not higher management knew about the supervisor's discriminatory motive. Harassment is the only type of discrimination carried out by a supervisor for which an employer can avoid liability. Now let's look at each prong of the defense to understand it a little more clearly. The first prong requires an employer to exercise reasonable care to prevent and promptly correct any harassment. This means generally in the workplace and specifically as it relates to an employee being harassed. The Supreme Court stated, quote, Title VII is designed to encourage the creation of anti-harassment policies and effective grievance mechanisms. While the court noted that this is not necessary in every instance as a matter of law, failure to do so will make it difficult for an employer to prove that it exercised reasonable care to prevent and correct harassment. None of the points seen here are requirements under the law, but they are suggestions that can help an employer prove that it exercised reasonable care to prevent and promptly correct harassment. Creating and implementing concrete policies on how to deal with harassment in the workplace is the first step. These policies should also include complaint procedures for its employees and a provision against retaliating against an employee who speaks out against harassment in the workplace. An employer should also establish what process it will take when a complaint is made, including how it will conduct an investigation into the complaint if necessary. It is advisable that an employer have at least one individual outside an employee's chain of command that is able to officially take complaints. Also keep in mind that an employer may need to take immediate action once it is aware of possible harassment in order to ensure that further harassment does not occur while it's conducting its investigation into the matter. Examples include making scheduling changes to avoid contact between the parties, transferring the alleged harasser, or placing the alleged harasser on leave with pay pending the conclusion of an investigation. An employer should be careful not to involuntarily transfer or place a complainant on leave, as that could be considered unlawful retaliation. An employer should make clear that it will undertake immediate and appropriate corrective action whenever it determines that harassment has occurred. While management should inform both parties about these measures, Montana employers must exercise good judgment regarding what information is disclosed to employees relating to disciplinary actions it takes in light of Montana's confidentiality laws. Disciplinary measures taken against an employee found to have engaged in unlawful harassment should be remedial, proportional to the seriousness of the harassment, and designed to put a stop to future harassment. An employer should keep in mind that it could be held liable if the harassment continues, as the measures taken against the harasser may be deemed ineffective in those circumstances. It is advisable for an employer to keep records of all complaints of harassment. Without such records, the employer may be unable to identify when an employee has a pattern of harassing others. If an employee has a pattern of engaging in unlawful harassment, it can assist an employer with determining credibility in a complaint or evaluating disciplinary measures needed. Periodic training of both management and employees can be an effective workforce educational tool to remind employees of the law and their responsibilities, but also such training can demonstrate that an employer takes harassment in the workplace seriously. The second prong of the defense looks at whether or not the employee unreasonably failed to take advantage of preventative or corrective opportunities provided by the employer, or to avoid the harm of harassment. The employer has the burden of proving this element as well. It is not unreasonable for an employee to not report a first or second incident of minor harassment. An employee may hope that it stops, or the employee may tell the harasser to stop and give the harasser an opportunity to end the harassment before complaining to management. If the harassment continues, delay at that point could be unreasonable. However, there can be other reasonable explanations for an employee's delay to make a complaint or use the complaint procedure, such as fear of retaliation or that the complaint procedure would not be effective. In this situation, for an employer to successfully establish this second prong, it would have to prove that the employee's belief regarding potential retaliation or an ineffective process was unreasonable. This is why it is important for employers to communicate to employees that retaliation will not be tolerated and to outline the actions it will take to effectively address a complaint of harassment. Usually, an employer can satisfy the second prong of the affirmative defense if the employee unreasonably failed to utilize its complaint process. However, if the employee made other efforts to avoid harm, this element cannot be established. Other efforts to avoid harm include filing a complaint with the Bureau, the EEOC, or filing a grievance. Remember, an employer must satisfy both elements in order to successfully claim the affirmative defense and avoid liability for a supervisor's harassment. If a supervisor harassing an employee based on a protected class then takes a tangible employment action against the employee that is linked with the harassment, there is no affirmative defense available to the employer. However, in such circumstances, a disparate treatment analysis of the adverse act will be implemented. Under this type of analysis, if the employer produces evidence of a non-discriminatory reason for the tangible employment action, a determination must be made whether that explanation is a pretext designed to hide a discriminatory motive. If there is a finding that the tangible employment action is linked to the preceding harassment, the employer is liable for the entire pattern of misconduct culminating in the tangible employment action. However, if the tangible employment action was based on a non-discriminatory motive, the employer can then raise an affirmative defense to the harassing conduct. If it is determined that an action does not rise to the level of a tangible employment action, the act may still be considered along with other evidence as part of a hostile environment claim that is subject to the affirmative defense. For example, if a supervisor only threatens an employee with discipline or discharge but never carries out the threat, that will not be a tangible employment action but may be considered as part of the offensive conduct that makes up a hostile work environment claim. Harassment carried out by an alter ego of the business is automatically imputed to the employer. An alter ego is an individual who is of a certain class or high rank within the organization that he or she would be treated as the business's proxy. These include the president, the owner, a partner, or a corporate officer. If the harasser is an alter ego, the employer cannot raise the affirmative defense. So what are the consequences of a hostile work environment or harassment in the workplace? Why should we care about it? There are the obvious direct costs associated with an employer paying to defend itself against a complaint. Attorneys are not cheap. And that goes for complainants as well, since at a certain point they need to hire someone to represent them as well, and even if it's not an hourly fee, there will be likely expenses in pursuing a claim beyond the Bureau or EEOC. Then there is the all too true adage that time is money. Think about how much time will be used up in a workday for managers and employees to be deposed or testify. But there are other considerations as well. There are indirect costs to employers. Targeted employees and coworkers who see harassment occurring in the workplace are not going to be as engaged in their work. Their productivity will suffer, and the toxic work environment that is created can go well beyond just the employee who is being targeted and result in a high turnover of employees. And you better believe that if the press doesn't care about any ongoing harassment litigation, your workers will talk and spread the information, leading to a damaged reputation. But for the last several years, in the age of different movements and hashtag-dominated social media, harassment has been heavily on the radar. The best any employer can do to avoid these negative consequences is actively create a respectful and inclusive culture where all employees can focus on doing great work. Whether or not conduct is unlawful harassment can be a fine line. It can be hard to determine at what point a comment or touch can cross the line, and everyone is entitled to their own beliefs and opinions. However, behavior intended to be disparaging, mocking, or provocative based on a protected class will likely cross that line. But regardless of whether or not conduct is just in poor taste, is harassing, or is severe or pervasive enough to become unlawful harassment, understanding that certain things are off limits is just good policy in promoting a respectful and inclusive environment where all employees feel valued in the workplace. So while it may be a fine line or a gray area, it just makes sense to avoid disparaging comments or jokes about a person's sexual orientation or gender identity, a person's religious beliefs or practices, a person's political views, a person's age, a person's mental or physical abilities, a person's appearance or physical features, a person's cultural aspects or practices, or where someone is from. And while there are plenty of things that may fall into a gray area or straddle the line, there are certain words and behaviors we should all agree have no place in the work environment. It should never be acceptable to imitate a person's accent or physical disability in a mocking manner. It should never be acceptable to call someone a derogatory name based on their race or sexual orientation. It should never be acceptable to call someone retard or ask them if they took their meds. It should never be acceptable to refer to someone as a terrorist because they are of Middle Eastern descent. And it should never be acceptable to not respect someone's physical boundaries by touching them inappropriately. As reviewed earlier, while owners, managers, and supervisors have a heightened responsibility for the workplace environment, at the end of the day, as coworkers, we are all responsible for creating and participating in building a respectful and inclusive place to work. We should all take responsibility if we cross the line. No one can get it right 100% of the time, but the key is to owning up to your mistake and being accountable. This can also be the case if you're a bystander and witness inappropriate harassing conduct. Don't be afraid to speak up for a fellow coworker who's being harassed. We should all do our best to make a friendly and engaging environment. It's okay to say, "Hello there, how are you today?" And it is always right to give credit where it is due and hand out sincere compliments. If you have questions about someone's beliefs, traditions, or culture, just to name a few, or if you aren't sure whether something is offensive or not, it is okay to ask. Just make sure you engage in that conversation and ask your questions in a respectful manner. Sometimes it is easy to forget the basics we learned years ago in kindergarten. Just remember, the golden rule still applies, and kindness is always acceptable. For more information about discrimination or the Montana Human Rights Bureau, please visit our website at www.montanadiscrimination.com or call us toll-free at 1-800-542-0807 or locally at 406-444-2884.